So with that, maybe the next slide, and I wanted to speak on the first trend, which is what the United States Supreme Court did this past year. Brandon gave a great summary of those key cases, but having followed this area for 15 years and now written over 14,000 summaries of decisions, I think probably there are two cases in the last 15 years that outweigh and are more important than any other cases. The first was in 2011, the famous Walmart stores v. Dukes case. And until this year, the second most important was probably the Comcast case. And those were two decisions that created impairments or impediments to plaintiffs trying to sue companies and trying to certify these huge cases. And that was until this year when the Supreme Court decided the Epic Systems case. And in my way of thinking, that's probably now the most important, or maybe tied for first place with Walmart stores v. Dukes, because Epic completely changes the dynamics of the playing field in federal court. When I go into court and defend our clients, and I'm armed with arguments based on the Epic Systems case, that is a game changer. And what we've seen in the latter part of 2018, coming into 2019, is class action litigation will never be the same again on account of the Epic Systems case. There's certainly the intellectual analysis of what the case says and the reasons behind it, but the practical impact of that case in terms of how it changes the way in which cases are configured, how they're litigated, how they're brought, how they're defended, how they're disposed of is bar none different in kind than any other Supreme Court case. So I think one of the takeaways in the Supreme Court, given that that decision was 5-4, is what a difference one person can make in terms of the nomination of someone to be on the Supreme Court and to be in a position to make a decision that can impact all companies, all workers throughout the United States. And there's a great example where one vote in a 5-4 vote changed the way in which class action litigation is litigated and defended and prosecuted forever. There's been a lot of talk about a legislative response to Epic Systems. In my way of thinking, it's not going to occur until there's a different party in the White House or a different party has complete control of the House and the Senate. It wouldn't be the first time that the United States Congress passed a bill to undo decisions rendered by the U.S. Supreme Court that occurred in 1991 when the Civil Rights Act of 1991 overturned about 8 Supreme Court cases that had adjudicated issues under Title VII. So I think that Epic Systems may even make its way into the presidential debates in the next round of elections, because the stakes are so high and the interests that are implicated are so pervasive. So by my way of thinking, and I think Brandon would agree, that was far and away one of the most significant trendsetters in terms of the dynamics of litigation. Next slide, please. I tend to view, and when I teach at Northwestern, I'm an advocate of the position that one way to view Supreme Court cases is from the viewpoint of, does it open the courthouse doors wider and invite litigants into the courthouse to bring their cases or litigate their claims, or does that decision close the courthouse doors and make it more difficult to either file the claim or litigate the claim, or easier to defend it? And so one way to view the major decisions of the Supreme Court in 2018 is from the vantage point of door opening or door closing. And I think people would have to agree that this was a term where the Supreme Court closed the door, narrowed the door, made it more difficult for class action plaintiffs to litigate their claims. Braden had mentioned the Encino Motors case in construing exemptions to the Fair Labor Standard Act. From a practical standpoint, what it means is more workers will have less viable claims and more employers will be able to dispose of those claims than ever before, because the Supreme Court reversed the thinking that those exemptions should always be broadly construed, because the public policy of the Fair Labor Standards Act, signed by Franklin Roosevelt during the New Deal, was designed to err on the side of workers. But the Supreme Court's decision reversed that trend, narrowed those exemptions, so I think has to be viewed as a door closer. The Janus case that Brandon had mentioned has the practical impact, not so much into class litigation, but to close some doors in terms of the ability of public sector labor unions to broaden their membership, so it's a pro-business decision. The China Agritech decision, although it deals with a very technical, arcane, nuanced issue of tolling, a lawyer's term for a delay pattern in a case and allowing someone to file a second or third or fourth class action after the first one was dismissed, that door has been closed off. In essence, there's one opportunity, one bite at the apple for litigants to bring these claims, and there won't be a second bite at the apple. And then finally, the Jesner case, probably a sleeper decision from 2018, in essence said the business of American plaintiffs' bar suing corporations in United States courts for alleged human rights abuses in foreign countries no longer will take place. U.S. courts won't have jurisdiction to hear those cases. Those cases should be litigated where they arise, in India, Cambodia, Chile, wherever, and U.S. courts will not entertain those class actions. So in terms of the United States Supreme Court and the trend and the impact of the Supreme Court, it basically made class action litigation more fraught with danger for the plaintiff side, made those cases a bit easier to defend on the employer side or the defense side, and had the impact in your mind's eye of closing the courthouse door a bit in this particular area. So very, very significant trend in terms of its impact on corporate America and the American people.